I call the next case, bar docket number 10805, in re Margot Burson. Please announce your appearances when you come to the podium. Ms. Baird, you may proceed.
Thank you, Justice Breyer. May it please the court, Kate Baird appears on behalf of the Disciplinary Administrator's Office. I'm a Deputy Disciplinary Administrator. Justice Breyer, I'd request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. The matter is here this morning before the court after the court issued an order directing the respondent to appear and show cause why her license should not be suspended pending the outcome of a disciplinary proceeding. Unlike the matter that the court has just considered, this matter has not yet proceeded to disciplinary hearing. A formal complaint was filed on June 6th, and the hearing is scheduled for August 17th. We do anticipate that the matter will be presented in a full evidentiary hearing at that time. We have not received an answer to that formal complaint, but that time has not yet run. Both disciplinary complaints that are pending before the Board of Discipline involve the respondent's conduct as a fiduciary. In one matter, she served as executor of an estate, a probate estate. In another, she served as power of attorney. Both of those roles arose out of attorney-client relationships between the decedent and the current resident of Brewster Place here in Topeka. There are three things that I would like to, 3 points I'd like to make this morning as I urge the court to consider temporary suspension in this case. One, I want to make the court aware of one circumstance that has changed since we filed the motion that I think is relevant to your assessment. I'd like to just briefly point out the factors that we considered before filing this particularly significant request for interim suspension. And then finally, I will be asking the court to consider, if you order a temporary suspension, some specific relief with regarding the notice requirements under Supreme Court Rule 218. The first matter, the change of circumstance, I think it's fair for the court to be aware that on June 1st, the respondent was removed as executor of the Dorothy Harvey estate. That is one of the matters pending. One of the complaints arises out of her role as executor. We, in spite of that, and that does provide one level of protection and does minimize, if not alleviate, the risk of future harm in that particular matter. We continue to believe that the facts warrant interim suspension, temporary suspension in this case. That removal occurred after a hearing in Shawnee County on June 1st.
Counsel, could I interrupt you just and kind of ask a big picture question? In the case we just heard, your colleague from the Disciplinary Administrator's Office relied on stipulations and sworn testimony.
Yes.
And the reason I interrupted now is because you said the facts establish, and I'm not sure we have any facts. We don't even have an answer filed to the complaint. I guess my question is, how are we to approach this kind of a case? Do we have articulated legal standards by which we judge these kind of motions?
Well, in the matter of In re Michael Friesen and more recently in the matter of Charles Ball, both docketed under attorney docket numbers, the court articulated that interim suspension, and both of those involved matters that were presented to the court prior to an evidentiary hearing. The court articulated that temporary suspension under Rule 203B, which is what we are requesting, pending final disposition, of course, is not for the purpose of punishing a respondent, but to protect clients from injury and loss and to maintain the integrity of the reputation, the integrity and reputation of the legal profession. temporary suspension is utilized where the conduct constitutes a serious crime or arises out of the respondent's practice of law, which there's no question in this case that the facts arise out of the respondent's
Well,
practice of
and
law.
I understand that that's true. I guess I'm just struggling with this question of how do we resolve these before, for example, we even have an answer filed. You're asking us simply to accept as true the allegations made by the disciplinary administrator's office.
Well, we are asking the court to conclude that the facts are of sufficient concern to do what the court has done, and that is direct to the respondent to appear and respond to that and show cause why these facts do not evidence sufficient facts to find that there is an immediate risk of harm.
Thank you.
Well, I was going to ask how the immediate or the interim suspension of Ms. Burson's law license is going to solve any immediate problems. Now, your new information about her not being the executor of the estate is very significant. How would it solve Brewster Place's immediate problem? She'll still be that one resident's power of attorney. How are we going to get a new power of attorney in there to file that Medicaid application?
Well, that actually takes me to the third point that I hope to make with the court, and I will, in response to your question, Judge Malone, I think that I'm going to be asking the court, should you conclude that the facts warrant temporary suspension, and we certainly believe that they do, that the respondent be ordered to comply with Supreme Court Rule 218. Now, Supreme Court Rule 18 requires attorneys to notify clients in writing and withdraw from their cases, notifying their clients in writing that they're no longer authorized to practice law, no longer authorized to represent them. In this case and under these facts, I would ask the court to consider including the instruction that withdrawal include withdrawal from any fiduciary responsibility or role that client has granted to the attorney during the attorney-client relationship. The designation as power of attorney by a client under these facts, I would ask the court that you consider that notice include a withdrawal from that fiduciary responsibility, and frankly from any fiduciary responsibility that she has been granted by any attorney in an attorney-client relationship.
So any fiduciary or representative role,
Yes.
basically, is what you're saying.
That arises from an attorney-client relationship.
Has the person that granted the power of attorney been notified of that request?
No, no, Justice.
Because a person can request another to be their attorney in fact without that other being an attorney. I mean, you can hold the
Correct.
power of attorney without having a law
Right.
license, and it seems to me a person is granted the freedom of picking their own fiduciary. And so if I had an attorney in fact before someone takes it away, I'd want my say-so. I mean, why isn't there some due process for the person that's granted these rights?
Well, in this specific case, and frankly, I hadn't considered communicating with the client is 96, a resident of Brewster Place, and we have not communicated with her concerning her choice.
I understand the practical aspects
Right.
of this, but we're talking about the legal aspect.
I suppose one remedy might be to notify the client of the suspension and inform them or seek to withdraw. But I understand the court's concern that persons have the opportunity and right to select a power of attorney, but under facts like this, and the second matter that I was going to try to address with the court is that so often in probate matters we're dealing with folks that don't have a voice. They don't have the opportunity to say, or I have a concern about how my finances are being executed. That's why they have, or that in some cases maybe why they have an attorney in fact at all.
Ms. Baird, I'm looking at paragraph 4 of your complaint, and I guess it bleeds over into paragraph 5. You've got the respondent acknowledging that her client is eligible for Medicaid benefits and that the application would be completed by January of 2016. And then in paragraph 5, you say the investigator contacted the DAO and the respondent failed to complete the task by the end of the year. Now, are you talking about the end of 2016?
Yes.
So nobody looked into this from the end of January until December of 2016? Why would we not follow up on February 15th of 2016? Doesn't make it looks to me like there's some real delay going on here.
Delay by, I'm afraid
Your
I'm not-
office. I mean, it seems like the problem is compounded by a lack of follow-up.
I guess I'm not entirely understanding.
You're telling us that the investigator didn't say anything to you until December of 2016, which is about 11 months after the promised from the respondent that she would complete the application. I don't understand what happened during that 11 months.
Well, the matter wasn't brought to our attention till October of 2016.
Right? Okay.
So in October, we became aware of the complaint by Brewster Place.
I see.
The matter was referred immediately to an investigator. So the investigator spoke with the respondent, spoke with the complainant, and so within 2 months.
So the investigator didn't report back to your office after the representation was made that's stated in paragraph 4. I mean, you literally don't know anything. Your office, the attorneys in your office don't know anything about what's happened in paragraph 4 until October of 2016.
We certainly didn't until October of 2016, when the investigation was initiated.
Well, but an investigator is talking to the respondent and getting an assurance that the application would be filed in January of 2016.
By the end, I'm sorry.
And you're saying the investigator isn't going back to any attorney in your office and doing anything and then waiting 10 or 11 months to see whether something has happened. You had a promise from the respondent that the application would be completed by January of 2016, and I want to know why an attorney in your office didn't know that contemporaneous with the representation, and then why there was no follow-up until the end of the year.
When we became aware that the application had not been completed by January 31st of 2016.
Which you didn't learn until October of 2016, right?
I think, I may, yeah, that's my error. It was October of, I'm using the wrong year, the reference. We learned of this in October of let's see, I have to go back here. That should be December 31st of 2016.
Which should be December of 2016. That's when an attorney in your office became aware of the complaint and assigned an investigator. Just help me out here. And the reason I'm pressing on
Right.
this is because you're asking for immediate relief, and it looks
Right.
to me like you guys sat on your hands for 10 or
Right.
11 months. So why should
You're
we press this matter now?
The January 31st is January 31st of 2017.
17.
And I apologize for that error, and I apologize for the time that's been taken, but that should be January 31st of 2017.
So your attorneys become aware in October, and the investigation kicks into gear, and the promise is made in January of 2017.
Yes,
Okay.
And the promise was what?
that it would be done.
By the end of the year or by the end of
January.
January?
The end of January.
So what was the reference to the end of the year? Was that an earlier promise, i.e. you get the case in October and there's some kind of assurance made that, oh, well, we'll get this done by the end of the year?
I'm not sure which reference, and I may have been here
It's
in
the
my
first
argument.
sentence in paragraph 5. The investigator contacted the disciplinary administrator when the respondent failed to complete the tasks by the end of the year. And since your reference above that
Yes.
is January of 2016, it makes it look like the reference is to December of 2016. I mean, quite honestly, if the January 2016 date that's in this complaint is actually supposed to be 2017, then paragraph 5 makes no sense.
I don't disagree with you. The investigator contacted, and I did not bring the investigative report with me. The investigator contacted our office after being assured by the respondent during his conversation with the respondent that all acts would be completed, and and right now from memory, it's my recollection that it was to be completed by the end of the year.
Meaning the end of 2016?
Yes, the end of 2016.
So the investigator who contacted your office is an investigator from outside the office, obviously.
One of our volunteer investigators here in Topeka.
Okay, but that person didn't end up working on this because of your office, or they did begin working on it because of, I'm sharing some of the confusion about the timeline here. There was an investigator involved prior to the October 16 contact to your office. Or no, I mean, it doesn't make it, are we talking about two different investigations going on here? The one that predated October and the one after?
No, we received the complaint from Brewster Place in October
Directly
of
from Brewster.
2016.
That makes more sense.
And it was assigned to an investigator.
Okay.
That investigator undertook efforts to determine the status, the merits of the complaint, met with the respondent. The respondent shared information about, admitted that the client was benefits eligible. That steps should have been taken earlier in 2016. That by mid-2016, everything was in place for the client to have secured Medicaid and for the Medicaid to kick in. She articulated some concerns about what was preventing that from happening, but assured the investigator that it would be completed. And as I stand here today, my recollection was that it was to be completed by the end of the year and of 2016. When that didn't happen, our office was contacted by telephone by the investigator expressing a concern in part due to the age of the resident and the extent of the outstanding funds due Brewster Place. Brewster Place had indicated that they did not want to, they wanted to continue to provide a residence to their resident, but bills were accumulating. The investigator did then complete the investigation and submit the report to our office. We asked the respondent to come in and meet with Mr. Hazlitt and myself concerning the matter. That meeting took place on February 8th. So it is my recollection as I stand here, and I apologize for the reference to January 31st of 2016 in paragraph 5, as it is my recollection that the assurance was made that the application would be completed by the end of the year, December 31st of January 15. And when that did not happen, we were contacted verbally by the investigator and continued the investigation, well, at least worked on working with the respondent on February 8th.
Doesn't some of this confusion illustrate the perils of what you're asking this court to do? Suspend somebody's law license on the basis of allegations and recollections, and really I don't see anything of evidentiary value here. And that's not a comment on the merits of the allegations, really on their form. I'm just not sure what we have to hang our hat on to do what you're asking us to do.
Well, I think it illustrates my error in the date in paragraph 4. I know it illustrates that, and I apologize.
Well, I
for
think
that.
maybe more responsive is you have the one interim step that on February 27th, the review committee for the Kansas Board of Discipline of Attorneys found probable cause that respondent had violated the rules.
Right.
And so you have akin to a preliminary hearing being in the middle of all that. So it's not bare allegations, it's allegations that have formed the basis for probable cause.
Yes.
But my question is, that happened on February 27th.
Right.
And so as of February 27th, someone should have been on notice that a 96-year-old woman was being neglected. The motion for temporary suspension is filed May 8th, and today is June 15th.
Right.
And I just think that a motion for temporary suspension should be some sort of expedited procedure if we have people at that much risk to warrant a pre-conviction suspension, and I'm a little concerned with that timeline.
Well, I mentioned that we met with the respondent in February. Assurances were made to our office that the steps would be completed. They were not completed within the weekend as was articulated then. There were steps taken that began the process. The application, a surrender of a life insurance policy was requested. An application was made. We learned later that the application was incomplete. And the complaint came in as well as the Dorothy Harvey estate came in as a lack of diligence. We were concerned in both cases with a lack of diligence. We met with the respondent. There were comments made by the respondent indicating that there were factors that were contributing to the delay, but she was adamant that she could complete the tasks necessary. When it became apparent and the concerns became grave that in fact this was not going to happen, we asked the district court judge, chief judge of the district court, to consider entering a Rule 221 order, which we had informed the respondent we would be doing. We indicated that there may be a method to appoint an attorney to assist her in not only with these cases, but what she had said to be was closing down her practice. The judge did enter an order, a Rule 221 order, directing 2 attorneys to assist her in taking all of the steps necessary to protect her client Rosalie Griffin and Brewster Place, as well as the Dorothy Harvey estate. There was an initial meeting, and throughout the month of April, it became more and more apparent that the respondent would not cooperate in or accept the assistance of those attorneys. At that point, we determined it was appropriate we had received the investigation in the second matter, the Dorothy Harvey, the probate matter. She was not cooperating in that investigation, and we subpoenaed the estate account records from the Dorothy Harvey estate, and in reviewing those records, and quite frankly, it turned the sense of the misconduct and the harm facing the clients changed in an assessment of those bank records, where it was clear that while not cooperating in the investigation, transfers were being made from the estate account to the respondent's operating account without authorization of the court.
Made the conduct look more nefarious. Is that a fair description? Yes. So in essence, your response to all these questions is we were working on it, things were happening, the situation was fluid. What started out as a lack of diligence investigation became client monies jeopardy kind of investigation, but not until shortly before the filing of the motion.
Yes.
And I have another question. This is just a brass tacks question. When is the answer due from respondent?
The formal complaint was filed on June the 6th. It should be filed certainly by the end of the month.
Okay. But obviously this proceeding also is an opportunity for her to come forward and make an explanation of her behavior. Okay.
And she had opportunity to explain to the investigator with regard to the Dorothy Harvey estate by way of cooperation in responding to the complaint of the Peters. They reside in Oklahoma, the complainants in that case. She has had opportunity to respond to the investigator, to respond to our office, certainly has opportunity to explain her conduct here this morning. But yes, and frankly, the respondent had not articulated a position that she was not capable of practicing or providing legal services because of depression, because of these other factors. In fact, it was quite the contrary. She articulated factors that were contributing to difficulties getting these done, getting tasks completed, but was insistent that she was absolutely capable of protecting her client. She indicated an intent to close her practice as the summer months approached and wanted the opportunity to wind that down. And at that point, we felt it appropriate to offer any assistance to her as she tried to do that. Again, when we obtained the records from the estate account, there was certainly a grave concern that there were injuries to the client that went beyond a delay in the proceedings getting closed.
Any other questions?
May I just very briefly address the point that was raised earlier? If the court determines that these facts warrant a temporary suspension, we would ask that you consider directing that the respondent comply with Supreme Court Rule 218 and withdraw at least in this case, but it's our position that it's appropriate that in this matter she be required to withdraw from any fiduciary role that was granted by a client in an attorney-client relationship.
Thank you.
Thank you.
May it please the court, Marguerite Burson, appearing in person. First of all, regarding the confusion about the timeline, the January 31st date would be 2017. The investigation began to my contact in October of 2015. I'm sorry, 2016, and the reference to the end of the year was December 2016. The indication of a completion of an application for Medicaid was for January 31st of 2017, and that application was completed within the first week of February. So it was in fact later than the 31st, I believe, but it was completed by the first week of February. A copy of that application was sent to the disciplinary administrator's office. To back up a bit,
Well, I'm confused. If the application was completed in February of this year, why hasn't it been filed and processed?
Well, it was filed, Your Honor, but the process with the current agencies handling this is to assign it to someone to review, and then if there's additional information needed, ask for that. And we're in the additional information asked for that stage. And I have...
But it just doesn't seem to be, it shouldn't be this complicated to get a 96-year-old woman her Medicaid benefits.
Well, that's something you'd have to take up with the administrative branch of government. Unfortunately, it's not an unusual situation as far as that goes from the date of application to completion of the process. We're fortunate that she has not, that she has continuing care as this is pending. She absolutely is entitled to that, but the documentation of any transaction within the last 5 years proving that this was a proper transaction. She had a condo that had to be sold. She had a car that had to be sold. Those kinds of documents have been asked for. And that's unfortunately not terribly unusual for the practice.
So at what point in time did you get involved in her representation while she was for the entire time she's been in the nursing home? Or?
Yes.
Okay. And
actually,
at what point
it goes
in time...
back farther than that. My first representation of the individual was with her husband and herself in regard to their disabled adult child.
Okay.
And
so at what point in time did you become aware that her money was running out and she was going to have to apply for Medicaid?
That was becoming obvious during 2015, but the difficulty in determining whether or not her son would be able to reside in the condo, given his limitations and the fact that he receives Medicaid assistance, and whether the condo would be considered something that he could continue to reside in, or whether it was an asset that had to be sold.
Okay.
During 2016, it was determined that he was unable to remain in that location and comply with the resident requirements and what have you, and so it was immediately sold. And so there were some matters of clearing up which assets were being retained, and then once determined they would not be retained, it became an asset that had to be dealt with and sold.
Okay, and
So-
this is a legal question, not, once you make the Medicaid application, because the indication is that by February of 2017, there's now a bill racked up at the nursing home of $99,000.
Yes.
So does Medicaid back pay?
They will back pay part of that.
How much of that will they back
I'm
pay?
not certain.
Okay.
Let me ask you about the check dated March 10th, 2017 in the amount of $3,991.04.
As to who,
There's a check that is attached to the emails that you sent to Carol Bonebreak.
okay.
Where'd that money go?
That money went to, it is in her account.
All of it?
Yes.
It has not been dispersed?
No, it has not.
Why hasn't it been paid to Brewster Place?
I was in the process of completing her tax returns, and unfortunately, even though she is paying high medical costs, those costs are not deductible to the state of Kansas, and determination of the exact amount of her tax liability was being determined, and the funds that have accumulated were to be sent with the response to the request for additional information. If I may, before we go any further, I made a determination during the month of September that I would be shutting down my practice as of the 30th of 2017, which is the end of this month. I have taken no new cases since the 1st of November. And my purpose in appearing today was to ask for the suspension to be extended to the 30th of this month, at which point in time I will not be practicing in regard to any client.
You mean to delay any imposition of a temporary suspension until the end of this month? Is that what you meant to say
Yes.
just now?
Yes.
Including the woman that you have power?
If all of the documentation is satisfactory at that point in time, then I would be able to be completed with that.
I want to know more about this money. So the 39, I'm just going to short circuit this and just say the $3,900.
Sure.
I guess we could call it the $4,000.
It was a life insurance
Let's just call it
policy.
$4,000 for
Right,
the
the
life
life
insurance.
insurance policy.
Okay, that went into a Caw Valley account. Who can draw money from that account?
I can.
Is there anyone else who can draw money from that account?
No.
How much money is in that account?
At the present time, there's approximately $11,000.
If we were to agree to hold off the suspension until the end of this month, can we also say that you won't disperse any of the money out of that account?
I was prepared to send the check to Brewster, but that would be the only, and there is a,
You mean to deplete the account by sending a check to Brewster?
it wouldn't deplete the account 100%, but it would bring it down to the less than $2,000 requirement that is necessary for Medicaid. There's a pharmacy bill pending that of a small amount that needs
Can
to
we
be.
agree that there are no fees on
Oh,
your
no.
part that are owed out of that amount?
Oh, no.
We can't agree to that, or we can't?
Oh, sure, yes, I haven't charged fees on this for some time. The only checks that I was anticipating writing were checks to Brewster Place, to a Preston Pharmacy, and I believe a dentist is outstanding.
You indicated that if the Medicaid is, if she's eligible for Medicaid, some of this built up in fees is not going to be reimbursed. Does she have any assets that are outside of what she's, does she have any assets that are free from Medicaid that she would have to delve into to pay off what she owes at Brewster Place?
She has minimal personal property at this point.
But
So
she,
there is nothing.
I mean, are we just talking about what's in her room at the, I mean, does she I'm not that familiar with
Sure.
the Medicaid rules, but I know that there are some things that Medicaid will let you have
Right.
that isn't counted against you.
Right.
So I guess what I'm getting at is because of the delay in filing her Medicaid application and the fact that she's not going to be able to get full credit for that bill toward Medicaid, even if it's now approved, is she going to be harmed by other assets that would have been protected, would have to be garnished to pay that amount? Are you following me?
Yes, I understand. Technically, under the rules of Medicaid, she'd be entitled to keep a vehicle. But the vehicle she had was being deteriorated and was costing her money, and she obviously was not going to be driving it. And her disabled son, although he has some abilities, had no use for two vehicles. Having an alternate as well. So that vehicle was sold. The excess property that does not fit into her room at Brewster in the way of furnishings was sold at auction by a reputable dealer. And the only property of any significance that is not in her room is some personal jewelry that's in the safe at Brewster and some silverware that they're making.
And do you
a
know a
market
value
for.
of any of that?
I don't know the value of either of those items. I don't think they're terribly significant.
Are those types of items exempt from the calculation of Medicaid eligibility?
Excuse me?
Are those types of items not counted in the calculation of Medicaid eligibility? Does she have to divest of those types of items?
Those items don't have to be specifically valued.
Okay.
They're personal property furnishings types of things that are not. They weren't a collectible
Okay,
kind of thing.
okay, thanks.
We've liquidated as much as we can on her behalf.
Does she have other family besides the disabled son?
She has a sister that was in a nursing facility before she was, due to physical reasons rather than,
I specifically mean children. Does she have any other children?
other than the disabled son now.
Okay,
And
thank you.
he has a guardianship that is assisting him. She has a niece that.
And are you his guardian?
Excuse me?
Are you his guardian?
No, I am not.
Okay,
No.
okay. That's all, thanks.
If you're asking us to delay the temporary suspension order till the end of the month, which is really just 2 weeks, what's the downside in not doing it today?
The downside.
Since you have no other clients.
Yeah, the downside would be is I have 3 estates that I have a draft for final accounting and final settlement.
So you do have some other clients besides
Yes.
this one?
Yes. There were estates that were opened earlier in 2016 that are due for closing at this time. And
But you haven't filed a petition for final settlement?
not as yet, no. I have not.
Well, once you file that petition, you have to give notice, don't you?
That's true.
And you have to have the court approve it, sometimes with a hearing. How is that going to be completed by the 30th of June?
The thing that would be helpful is if I could at least handle the final tax return and the final accounting. And then the attorneys that have offered to work with me would be able to do the representation beyond that point.
You've been in contact with other attorneys to hand these matters off if you don't finish them?
Yes.
Are these the same lawyers who've been assisting you through the district court
Yes.
in this proceeding?
Yeah,
Okay.
not in those proceedings as of yet. Those cases are ones that I was attempting to handle myself.
Okay, these are outside the proceedings that have gone
Yes.
before today.
Yes.
These are other attorneys we
irrelevant
haven't
to
heard
this.
about, or
No.
who are they?
There's an estate of Patricia DeLay.
No, I don't mean the cases. I mean, who are the attorneys who are helping you with them, or who are going to step in as soon as you step out?
Carol Baker and Merrill Befort.
Okay.
And those are the same two that have been helping you in
Yes.
this case.
We had a miscommunication, apparently. Any other questions? Any other remarks? that you'd like to
Your
make?
Honor, the need to shut down my practice in general is related to health issues, arthritis, which I have had medical treatment for since 1985. It had been my assumption I'd be practicing until my 90s, but in the last 3 years, it has become increasingly difficult to predict when the difficulties relating to the arthritis would prohibit my being able to get to the office and work on client matters in a timely fashion. Previously, we all know that if we go out and do certain things on the weekend, that we pay for it. My arthritis has progressed to the point in which I have days in which I have difficulties and pain which are unrelated to any previous activity. So I'm unable to schedule and follow through in as routine a fashion as previously practicing. I struggled with this for several years, trying to get this under control. I have begun some new medication regimens and what have you, but it became clear to me by the end of the summer last year that it was time to do something else. It was not going to be a matter of me being able to practice in the way I expected to practice, and that the stress of handling cases with controversy, which estates are not necessarily exempt from, was increasingly difficult and aggravated my medical conditions. So I have been in the process of closing down my office, and that has necessitated some downsizing and moving around within my office building, and some of those matters have contributed to delay in being able to respond. Unfortunately, the medical situation continues to be a challenge as far as scheduling and completing of tasks. But I do believe that the last 2 weeks of this month can be used profitably for the benefit of some other clients. And I would just ask that any suspension be delayed until after the 30th of this month. It is my intention that I will not be renewing my license July 1, and have been directing clients that I will not be available for any matters whatsoever, and have referred clients and in the last 2 weeks resigned from a power of attorney with another separate client, which I initiated due to my retiring. And at the present time, I do not have any active cases in which, or powers of attorney in which I am a signatory on any accounts.
Who's going to be the new power of attorney for the resident at Brewster Place?
The next one would be the niece who resides in Missouri.
Is a contingency?
Yes.
Okay.
Yes.
I have one more question. On page, I guess they're not numbered, so it would be the second to the last page of the motion before us today. There's a list of transfers made from the estate account to your operating account. Can you explain those to me? Were those all for fees? What were those for? Those transfers from the estate account to your operating account?
Those were fees, Your Honor.
And have you submitted any documentation to the disciplinary administrator's office to illustrate that those were for fees? Any
Not as
bills?
yet, Your Honor.
Well, probate fees have to be approved by the court, don't they?
Yes, Your Honor.
I take it these weren't.
Not as yet.
So what authority would you have to take the money out of the account if they hadn't been approved by the court?
At this time, I decline to answer.
I'm sorry, what?
I said at this time, I decline to answer.
Are you taking the Fifth Amendment?
Yes.
Any other questions?
So do I understand you correctly that you're agreeing that suspension is appropriate at this point? You would just like us to wait until June 30th?
Yes.
Okay. That's the only question.
Okay. Thank you, counsel. Ms. Baird?
May it please the court, you have information from the respondent now that there are at least 3 other estates out there that are due a final accounting and have to be closed. There is information before the court that funds were transferred from an estate account when she was executor within the last 12 months, beginning in August of 2016, ending in January of 2017, from an estate account directly to her operating account. She's acknowledged that those were not authorized by the court. There is no question, there's no controversy concerning those facts. The respondent has articulated to the court much of what she articulated to our office back in February. I'm going to close my practice in June. Let's just let this go until I'm going to close my practice end of June. Let's just let this go until the end of June. She's also provided to the court 2 names of lawyers who will be taking over. However, the information before the court by way of affidavit is that she was refusing to, or not cooperating with those lawyers as they were meeting with her or trying to meet with her to take care of or help take care of these matters. The client files weren't produced. As of yesterday, there was no change in the status at Brewster Place of an application being made. There was an application made, but it was incomplete, and the respondent was informed that information needed to be provided by May 2nd. There is no indication that anything has happened since then. And as of February 24th, my dates are, as of May 24th, the obligation to Brewster Place exceeded $117,000. When we look at not only the potential injury to these clients, but to other decedents, to other estate accounts, it is our position that the facts support a decision by this court that immediate interim action needs to be taken, her license needs to be suspended, and that she needs to be directed to withdraw from any fiduciary position that she currently holds. Unless there is a question by the court, that would conclude the comments that I would make.
Any further questions? Thank you. Thank you for your remarks. This case will be taken under advisement.